Right, with me now, former Manhattan prosecutor Jeremy Saland and former Trump White House lawyer Jim Schulz. Jeremy, let me just start with you. When you first heard that the jury wanted to hear David Pecker's testimony about conversations and meetings he had with Donald Trump, allegedly about the catch and kill scheme, what was your first thought?
My first thought is Donald Trump's team, Blanche, is not happy with that request. Why is that? Well, it's because we know we need corroboration of Michael Cohen. And where's that key corroboration? David Pecker. I think that's safe to say. Certainly there's the notes from Weisselberg, which are valuable, but these words from the mouth of David Pecker, it starts from 2015. It gets that narrative going that this is an effort to impact the election, and that conspiracy, as the prosecution is alleging, even though they have to prove that beyond a reasonable doubt, to promote the election. And it starts there. And then you get the words from Trump himself, and I think it was in reference to McDougal, where there's a question about to buy the story or not. And he says, I don't buy stories in substance. You talk to my guy, Michael Cohen. So it really connects all the dots and corroborates. And the strongest piece of evidence testimonial is David Pecker.
Deputizing, some people say officially in this testimony,
Somewhat.
Michael Cohen, empowering Michael Cohen. Jim, how do you see that?
So you don't know what they're looking at, right? I agree that, the defense is probably raising an eyebrow to that, but you don't know what they're looking at. And perhaps they want to look at it to see if it does actually corroborate it, right? They could be thoughtful through this process. Maybe they're not buying what the prosecution is saying on it. So I think it could cut either way. But I think the more time that goes on, I think Trump's defense team is right. The more time that goes on, and his surrogates are saying that, the better for him.
Time means they are still deliberating, which increases the chances of a disagreement, which increases the chances of a hung jury. Jim, let's talk about the jury instructions. Now, we don't know if they want to hear all the jury instructions read back 55 pages or just parts of it. Which parts, and I'll ask you for the defense, which parts would the defense most like to see read back to the jury?
Look, I am interested to see on the instruction on the underlying crime and whether there's confusion relating to that. That's something that's been an issue in this trial from day one. I think it creates some appealable issues down the road, some significant appellate issues down the road. And just because, there was this hiding of the ball of what the underlying crime was, and then it comes out that it's a campaign finance, perhaps tax, but it's still unclear. And if they're unclear on that, I think that sends an interesting signal as to how they're feeling about this case and the confusion associated with these layers that the prosecution has created as part of their case.
And I should note we are seeing Donald Trump's motorcade arriving at the Manhattan Criminal Court. It's very possible we hear from Donald Trump before he walks in. He has not been happy, obviously, not at all, over the last day. Seemed, in a way, a bit frustrated and dejected when the jury started deliberating. Jeremy, to what Jim was saying there, I'm not surprised, but I think that there was some conventional wisdom that if the jury's asking for instructions about the law surrounding the counts itself, that might be something the prosecution likes more. But if they're asking for the instructions on reasonable doubt, that's something the defense always likes.
Well, it's funny you say that. First of all, my response, I think his assessment is fairly reasonable, Jim, what Jim says in terms of a potential appellate issue. I don't think, first of all, and let me take that back, the prosecution did not hide the ball. The defense team and Donald Trump knew walking into that courtroom and throughout that trial what those underlying other sort of elevating offenses were to make this a felony. So it wasn't really hiding of the ball. The public may not have known, and it wasn't a Jack Smith, a speaking indictment to tell it, but it was there. I was in a reference reasonable doubt. The question for that is a great one. Who does that hurt more? Who does that make? Does it mean that there's 2 or 3 people in the jury say, is it reasonable doubt? Or does it mean that there's 9 of them trying to be convinced? But I'll say this too. We can sit here and all pontificate and try to read these tea leaves. None of us know nothing until that jury gives it to the foreperson and the judge reads a verdict.
2 things can be true. One, you can never know for sure what a jury is thinking. However, we do see the notes and we do see what they're asking for. Sure. So I do think it is reasonable to wonder why they are.
Absolutely. Any trial attorney absolutely wonders. It's the prosecution, the defense, no matter what hat you wear, you're wondering.
And again, Jim, as they go into court very shortly, Donald Trump, no doubt, sitting there and waiting. One of the possibilities that I think we didn't discuss that much leading up to is the possibility of a mixed verdict. There are 34 counts here, and the counter argument to the idea that this could take being a long time good for Trump. On a mixed verdict, They have to discuss which ones they would find him guilty of, and then which ones either they would be hung or acquit him on. You could see that taking a long time.
Yes, but I think it's less likely that you have some of the counts because they're all they all relate to business records, right? So I think it's less likely that you see some of those counts, not guilty, and then others that he's guilty on. I think it's more likely that it's going to be all or none, or the potential for a hung jury. I just don't see that mixed verdict. On each particular instance, I think it's going to be all or none, or a mistrial by way of hung jury.
No, there are some people who suggest the checks, the signing of the checks as opposed to an invoice. Checks is something there was a lot of testimony that Donald Trump spent a lot of time thinking about. Wasn't going to see a dollar or a cent going out without his thoughtful approval there. But we'll see. And the first thing we will learn is if the jury wants all the instructions or just parts, and which parts, and then we'll be able to talk about that. Jeremy Saland, Jim Schultz, great to see both of you. Thank you very much. Kate?